Hi everybody, this is Jeremy from Legal Studies Advantage. In this Success Tips video, we're going to discuss the topic of learning by case law. As you're all well aware, the case law method is the primary method utilized by most law schools to illustrate and teach the law. So let's talk just a little bit about this case law methodology. First of all, the textbooks that you will use are highly edited case books. They contain a table of contents and much editorial material that both introduces the various topics and cases that you'll be studying in each section and subsection, as well as providing commentary as to what the law is and the things that you should be paying attention to in the cases themselves. It may seem like an elementary thing to point out, but it's important to notice what the table of contents says. This can actually serve largely as your map and sort of as a compass to guide you through these cases so that you know what this particular case is actually supposed to be illustrating. So prior to reading your cases each day, take a quick glance at the table of contents, see what topics you have already covered, and see what the current cases are supposed to be illustrating. You'll want to use this to orient you as to the purpose of the cases themselves. Otherwise, it's not that different than just having a stack of cases on your desk and being told, "There, now go and learn the law." It is noteworthy that the most rich cases are the ones that typically are chosen by the editors and authors of these textbooks. These are the classic cases with well-reasoned explanations, those providing new interpretations of the law, etc. Those are the cases that typically have been chosen by the professors who created the textbooks. The second bullet point poses an interesting question. These casebooks typically utilize appellate court cases as opposed to trial court cases. Why is that? Well, at trial the facts are determined based on evidence and the applicable law is applied as understood to those facts. On appeal, the facts are usually left alone, as they have been settled by the trial court, while the meaning and application of the law to those facts is argued. Does this law really apply to these facts? What does the law mean? When does it apply? And so forth. That's why appellate court cases are chosen. They generally provide a very rich source of reasoning and argument about the different points of law that are being disputed. And so they provide a way both to learn the law and to learn general legal reasoning skills. We'll take the third and fourth bullet points together. First, cases show historical development and context, not always the current law. Also, cases show definitional nuances, minority rules, etc., but not always the law of every jurisdiction or state. So why then are those particular cases chosen? Well, be aware of this reality. One case may raise one issue or one point of law, while the next may go in a completely different direction. Part of the reason these cases may have been chosen in that particular textbook is to actually show the historical development of that area of the law, perhaps showing that cases were ruled one way, and then over time the law changed and evolved to point in a different direction. Also, various cases may look like they're dealing with the same question but come out in two different ways. In that case, it's important to identify what facts are different between the cases, as a particular definition may apply in one circumstance, but if the facts of another case is different, that definition may not apply at all. This is typically a way that is utilized by law professors to demonstrate the nuances and various distinctions inherent in the law. So why are certain cases chosen? Cases are chosen or included largely because of the discussion of issues in that particular court opinion. Often they are from one jurisdiction of a particular state, and therefore may not be the current law of another jurisdiction. The courts there in the second jurisdiction may not have addressed that legal question yet, or they may have decided it another way altogether. Law schools are intentionally trying to teach reasoning and issue spotting and legal terminology so that you know where to start your research on state-specific particulars in your practice later on. They also want students to know how to argue in writing and orally on their feet. This leads us to our last point, the material for class discussions, practicing legal skills. The case law method lends itself well to practicing legal skills and to having great class discussions. Often your professors may ask you questions and may expect you not only to recite the content and details of the case itself, but also to provide your own reasoning and arguments as to why a certain outcome should or should not be reached by the court based on the law and facts in that particular case. That concludes this Success Tips video. We wish you much success and sincerely hope that this provides you with a very real legal studies advantage.